further when it comes to the presidential results, because they feel like they were sidelined. That was their argument. They were sidelined and left on the side as the commission, the chairperson went ahead to, make the declaration.
For that, it is a heavy grievance that was made, and that issue was raised before court, and we had judges questioning about that, on whether it was valid for the chairman to sideline them, because the constitution provides that they should work together in harmony for the interest of the Kenyan public. However, we see that the constitution provides that the chairman of the commission shall declare the results. Also, when you look at our electoral laws, it provides that where there are less constituents, where the results are few results remaining for few constituencies, that won't affect the overall tabulation of results, then the chairman can proceed and declare the results. I do think Mr. Chebukati exercised his right and powers according to that provision of the law. Yes.
So he was right to go ahead and declare, despite having half of his commissioners actually not believing and standing with him?
Yes.
Okay.
Yes. Yes.
All right. So then let's look at because the hardiness. This is something that was actually raised in court. We are talking about, so why, I think one of the judges asked this, if not Martha Koome, why did he not wait? Because it's not like he was running out of time. He still had like a day to actually, do the 27 constituencies, then go ahead and, declare the results, even if it's the following day, and come together and tell the commissioners, because they feel like they are a little bit divided, come and sit down with us. Let's talk about the issues that you have and reach an agreement and say, okay, this is exactly what you have. That seems never to have happened.
The issue is whether it was in counting of time. Lawyers have different opinions, and I think the advisors of the commission counted from Tuesday as the first day. So when you count Tuesday as the first day, Monday is the last day. But when you count it from Wednesday, Tuesday is the seventh day. So it really brought confusion on which day, because if Mr. Chairman Chebukati had declared the results on Tuesday, that could be one of the issues even in court, because how do you count the seventh day?
Was there no way that they could have probably sought clarification from the courts and just, have that?
But you cannot raise that issue currently. You need to have raised it previously, so that the court can give you directions. Okay, because if the judges are arguing, then he still had an extra day, then maybe I think that was one of the judges. I think it was Justice Lenola who asked that question, and the IEBC lawyers say that they counted from Tuesday as the first day. That means then Monday was the last day to declare the results, and he sought for court's directions in regards to how do you count time. When we look into our laws, we never count weekends. Even so, our learned senior, Mr. Paul Mwite, he even told the court that
they have the power to actually...
They have the power to extend, because it is 14 working days, not 14 days. So how do you interpret that? Even if our seniors have challenges interpreting 14 days. Okay. Yes.
All right. Let's look at some of the, reliefs that the Azimio team was actually asking, and the directions that the court asked them to actually, if you want us to give this direction, and then you have also to guide us in exactly what you need the court to actually do in regards to this. So you want us to nullify the election and rule in favor of your candidate and say probably your candidate did win in this election, but at the same time you want us to go to the repeat poll without the referee, how do we act on that? How relevant and important is this question that the court was raising to the Azimio's petitioners?
For the court to give you reliefs, one thing I know is that you need to have proved your case beyond reasonable doubt. It is now upon the judges to compare what the evidence they were given and compare it to the law and see whether there were any irregularities that happened. In my view, the reliefs sought by Azimio, some of them were over-ambitious. I do not think the court will grant them.
Okay.
For example, the relief that they wanted Mr. Chebukati to be barred from office, that is not a relief according to the Constitution.
Okay. What is it?
The Constitution only provides for only 3 reliefs. 1, to uphold an election. 2, to invalidate. And after invalidation, 3 is to order for a re-election within 60 days. What Azimio team was looking for, I don't think the court will grant them.
Okay.
Some of them, yes.
All
But
right.
it's upon the court's discretion.
Okay, but this is the thing, because I heard Martha Koome say now, if we go into issues of barring Wafula Chebukati, that is not our mandate here, as the Supreme Court will be usurping powers of the other courts, I think the Magistrate Court.
Yes.
If at all that is the direction they want to take, then they have to go back to court again,
Yes.
a process that will be long again.
Yes.
Okay. So what are some of the other reliefs that you feel, apart from barring Wafula Chebukati to actually, take part in the repeat poll, that is there any other relief that you feel like this could actually be granted in terms of nullification or declaring Raila Odinga as the win?
I think those are the reliefs. However, they raised about 9 issues for determination. The issues for determination are what the court is going to look at is whether those issues are valid. And if those issues are valid, the court is going to make an order or it's going to make an announcement in regards to those issues. We expect some of the issues to be dismissed and some issues will be allowed. Yes.
Okay. Let's look at something else that was actually playing in the corridors of justice, and this is in regards to whether there was voter suppression and how they argue their case when we had the postponement of the elections, and just probably to get into why it is important, probably moving forward, how IBC should conduct itself with regards to this election. How do you take the arguments in regards to voter suppression in counties where results were actually, nullified? No, suspended rather, not nullified.
We saw Mr. Mohat making submissions in regards to that. For example, in Kakamega, where they cited voter suppression, I do not think there was voter suppression because the nearby county, Vihiga, had 54, 57% of voter turnout. In Kakamega, we even saw a low turnout. No, we saw a parallel one. It was about 56, yes. 56, the other one was 57%. In the neighboring Bungoma County, we saw a high voter turnout of 61%. When you go to Mombasa, whereby the gubernatorial elections was postponed, we saw that in Kilifi County, which is just nearby, we saw that the voter turnout was 62%. In Mombasa County, it was 61%. Does that really show there was voter suppression? I do not think so. The other issue we had is how do you prove voter suppression? Okay. Most voters didn't go back to vote in the mini election because of 1, 2, 3 reasons: economic challenges. We also have some people who are denied off because you can't tell me you working in Nairobi. Nairobi wasn't declared a public holiday, but in Mombasa it was a holiday. So most employers didn't grant offs because of that. Yes.
Okay. Okay, so you don't believe there was actually voter suppression? The arguments that they put in court, though?
There was no voter suppression, but I'm looking forward to the court's judgment in regards to that issue.
Okay.
Yes.
The 50+1, I think this is also an issue that played in the corridors of justice. The 50+1, because I see Okiya Omtatah was actually arguing that and saying, okay, we didn't have the 50+1. No candidate actually go to get the 50+1 threshold as it is required by law. From what was argued in court, and I know I'm trying to make you as the Supreme Court judge, but maybe you could be. From what was argued in court, what do you make of that? Do you feel the evidence provided was enough to actually convince the judges that, by the way, maybe no candidate got 50+1%?
I do not think the evidence provided in court could have overturned the declaration in regards to 50+1. However, we have an issue of whether the votes counted could have been totaled to the correct number that was displayed in the platform.
Okay, just hold your thought. All right, now we want to cross over to the Supreme Court, where the 7-judge bench will be delivering their verdict. I believe they are making their way right now and just settling down to make sure that they give Kenyans that which they've been waiting for. That is the verdict in regards to this election petition. Thank you so much for your time. We want to cross over to the Supreme Court. Live updates right there to get exactly what is going to be happening there, and we'll be coming back later on to just make sense of whatever judgment we would have gotten from our judges. Over to the Supreme Court. All right.
E003, E004, E007 and E008 of 2022, Raila Odinga and 6 others, versus William Ruto and 13 others. The Honorable Chief Justice and the President of the Supreme Court is presiding.
Thank you. Very good afternoon, ladies and gentlemen. Yes, this is the judgment of the court, which is delivered pursuant to Rule 23(1) of the Supreme Court Presidential Election Petition Rules 2017 in the presidential election held on the 9th August 2022. This is an abridged version of the judgment. The full judgment will be delivered after 21 days. Kenya is a sovereign, multi-party democratic state whose foundations are firmly spelled in the Constitution. The Kenyan people's quest for electoral reforms since independence is well documented. That notwithstanding, and even without going back to the pre-1992 era, every cycle of elections has been highly contested, with the exception of 2002. This speaks to a background of distrust of the administration of our electoral process. Informed by this setting, Kenyans made a decision to vest the Supreme Court with the jurisdiction to determine questions regarding the validity of a presidential election under Article 140 of the Constitution. The reactions following the declaration of results of the presidential election of 9th August 2022 shows that the Independent Electoral and Boundaries Commission, IEBC, has not yet garnered universal public confidence and trust in the internal management of the Commission and elections. On the 15th August 2022, 6 days after the general elections were held, Mr. Wafula Chebukati, the chairperson of IEBC, announced the following results. Raila Odinga, 6.942, 930 votes, representing 48.85%. William Ruto, 7.176, 141 votes, representing 50.4%. 9%. David Wahiga, 31,987, representing 0.23%. George Wajakoya, 61,969, representing 0.44%. Based on the aforesaid results, the chairperson of INBC declared William Samoei Ruto the first respondent, the presidential candidate for the United Democratic Alliance Party, as the president-elect. This declaration has precipitated a total of 9 presidential petitions that are filed before us, to wit, number 1, presidential election number 001 of 2022, John Njoroge Kamau versus Wafula Chebukati and 3 others, and Raila Amolo Odinga and 7 others named as interested parties. The second petition is presidential election number 002 of 2022, Youth Advocacy Africa and another versus INBC and 12 others. Third petition, presidential election petition number 003 of 2022, Kerif Khalifa and 3 others versus INBC and 3 others. Fourth petition, presidential election petition number 4 of 2022, David Kariuki Ngari versus INBC and 9 others. 5, presidential election petition number 5 of 2022, Raila Amolo Odinga and another versus INBC. 6, presidential election petition number 6 of 2022 by Moses Kuria and others versus Honorable Raila Amolo Odinga and 4 others named as interested parties. Number 7, presidential election number 007 of 2022, Okia Omtata Okoiti and others versus INBC and others. Number 8, petition number 008 of 2022, Julia Nyokabi Chege and others versus INBC and 3 others. And the last one, but not least, petition number 009 of 2022, Ruben Kigame Richete versus INBC and others. In addition to these petitions, we received a total of 24 interlocutory applications and 1 preliminary objection, which were filed in this court. 2 of the presidential election petitions were struck out. That is petition number 006 and 009 of 2022 for failure to meet the constitutional threshold as set out under Article 140 of the Constitution. On 29 August 2022, this court also admitted 3 amici curiae briefs by the Law Society of Kenya, the Kenya section of International Commission of Jurists, and John Warubengo and 2 others. Upon perusing and considering the issues raised in the remaining presidential election petition numbers 001, 002, 003, 004, 005, 007, and 8, the responses and the submissions filed thereto, this court found that all the 7 petitions substantially raised similar issues and sought similar reliefs. Consequently, on 30th August 2022, this court ordered that the 7 petitions be consolidated and designated presidential election petition number 005 of 2022 as the read file. From the consolidated petition, the responses filed and submissions filed by all the parties, the court crystallized the following issues for determination. And those issues are there. We have repeated them several times. I will not read them. Having considered and deliberated upon the consolidated petition, the attendant responses, submissions, and also considering the amici curiae briefs, we now make the following determination on issue number 1, which is whether the technology deployed by IBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. As noted in the introduction, lack of trust in the electoral system has endured in Kenya for a long time. This led to the introduction of electoral technology following recommendations made by the Independent Review Commission on the general elections held on the 27th December 2007, popularly known as the Kriegler Commission report. That report recommended integration of technology into Kenya's electoral process for registration, identification of voters, and transmission of results. These were enacted in Section 44 of the Elections Act 2011. By this statute, IEBC is enjoined to adopt technology in the electoral process. As a consequence, the IEBC developed a technology known as Kenya Integrated Electoral Management System, KIMS, making Kenya's election process an hybrid as it employed both technology and manual processes. The first, third, and fourth petitioners in the consolidated petition challenge the technology used by IEBC during the 2022 general election. They plead that the manner in which technology was deployed and utilized fell short of the prescribed constitutional and statutory standards. As regards the audit of the register of voters, they urge that IEBC, pursuant to its elections operations plan, committed itself to conducting an audit of the register of voters by 31st March 2022. To the contrary, they arrange it only publicly availed the audit report on its website on 2nd August 2022, which was only 7 days to the elections. In this report, it was noted that the auditors established serious gaps and risk to the electoral process, including numerous cases of change of voter stations without knowledge or approval of the affected voters. Grant of voter update privileges in IEBC, IDMs, to 14 user accounts and related to voter registration. Reducing the accountability of user activities in the register of voters. Presence of 11 active generic accounts on the MBIS application and the 2 MBIS users with the same logging identification. Risking unauthorized system users, possible interference, change of particulars on the activation of voters in the system. IEBC's failure to set up access, decertification, and user activity review process. And IEBC was also arranged to have failed to respond to requests by auditors for crucial information. On the integrity of the technology deployed, it was the case for the 7th petitioner that in order to comply with Article 86 of the Constitution and Section 44 of the Elections Act, the technology deployed must be simple, accurate, verifiable, secure, accountable, and transparent. On the simplicity of technology, the 7th petitioner contends that the KIMS kit failed the tests as they were not easily usable by ordinary citizens without expert knowledge. They further assert that IEBC was expected to procure and put in place a technology necessary for the conduct of the general election at least 120 days before the election and ensure consultation with the relevant agencies, institutions, and stakeholders. Furthermore, the petitioners arranged that IEBC violated its constitutional duty by delegating the design, implementation, and conduct of the KIMS components of the election to a foreign company, Smartmatic International Holdings, BV. As a result, IEBC staff and the public did not have full comprehension of the KIMS components. They conclude, therefore, that IEBC abdicated and surrendered its role to conduct elections to Smartmatic, and that IEBC vigorously fought any attempt to subject Smartmatic's activities to accountability and transparency, including the safeguards required by Regulations 61, 69, and 75 of the Elections General Regulations 2012. In response, IEBC has submitted that the electoral system met the constitutional threshold, that all the necessary information was accessed only by the authorized persons. The information was accurate, complete, and protected from malicious modification, either by authorized or unauthorized persons. IEBC maintained an audit trail on activities related to information, and that the information was available and could be authenticated through the use of various security features. In further response, IEBC contended that they engaged KPMG on 7th April 2022 to conduct an audit of the register of voters, which was submitted on 18th June 2022. In addition, it issued a briefing on the report on 20th June 2022, summarizing the thematic areas therein and disclosing its findings as well as actions taken to remedy the issues identified. It also conducted its annual audit in compliance with Regulations 11 and 12 of the Election Technology Regulations 2017 and a certification of compliance issued to it on 3rd August 2022. IEBC relied on sworn affidavits by Michael Ouma, Moses Sunkuri, and Hussein Majan on 26th August 2022, which were to the effect that it published the interim report by KPMG on 8th June 2022 and embarked on remedial measures aimed at effecting the recommendations ahead of publication of the final report. It was ascertained that it could not publish the full final audit report, as doing so would compromise the integrity and security of the electoral technology system, considering the provisions of the Data Protection Act, which imposes a duty to protect the data of Kenyan voters. On the other hand, the first and second respondents urge that even if there was failure of technology, it did not vitiate the result of the presidential election. Upon considering all the printing submissions and the ICT scrutiny and inspection tallying and recount report, which fully examined the IEBC's result transmission system, RTS, we are not persuaded by the allegation that the technology deployed by IEBC failed the standard of Article 86A of the Constitution on integrity, verifiability, security, and transparency for the following reasons. One, whereas it is true that the KIMS kit failed in 235 polling stations, 86,889 voters were granted the right to vote manually, and the requisite forms 32A were duly filed. This happened successfully in Kibwezi West constituency and parts of Kakamega County. Two, while the audit report was released to the public 7 days before the 9th August election, the register of voters was used at the election without any apparent anomalies. C3, Smartmatic was procured to provide the necessary technological infrastructure, as IEBC did not have the capacity to do so. No credible evidence meeting the requisite standard of proof of access to the system by unauthorized persons was adduced by the petitioners. The scrutiny report prepared by the registrar of this court did not reveal any security breaches of the IEBC's RTS. IEBC successfully deployed a biometric voter register system which captures unique features of a voter's facial image, fingerprints, and civil data to register and update voter details across the country and also in the diaspora. The BVR captures a voter's facial image, fingerprints, and civil data, which features are unique to each of the voter. In compliance with Section 6A of the Elections Act 2011, IEBC opened the register of voters for verification of biometric data by members of the public for a period of 30 days. Thereafter, the register was revised to address issues arising from the verification exercise. KPMG then audited the register, and we are satisfied that the inconsistencies and inaccuracies identified during the audit were somewhat successfully addressed. The second issue was whether there was interference with the uploading and transmission of Forms 34A from the polling station to the IEBC public portal. The first petitioner arranged staging that a person who had access to the RTS intercepted, detained, or stored Forms 34A temporarily to convert or manipulate it before uploading it on IEBC's public portal. It is arranged also on 11th August 2022, IEBC dumped over 11,000 Forms 34A on the public portal between 11 to 11:09 hours. To rebut this allegation, IEBC and its chairperson, in their response dated 26th August 2022, denied staging and unauthorized intrusion of the RTS. In that regard, they urge that every image of Form 34A was uploaded immediately after the transmittal of results. The form was received as evidence by the timestamp. Similarly, the first respondent denied these allegations. Our finding: 1, no credible evidence was presented to prove that anyone accessed the RTS to intercept, detain, or store Forms 34A temporarily before they were uploaded to the public portal. The allegation that 11,000 Forms 34A were affected by staging was similarly not proved. 2, the allegation that IEBC, its officials and strangers used a tool to tamper with the Forms 34A before converting them to the portable document format, that is PDF, that eventually appeared on the public portal, was sufficiently explained when IEBC demonstrated how KIMS captured and transmitted the image of Form 34A. Accordingly, we dismiss that allegation. 3, during the ICT scrutiny, it turned out that the transmission logs produced in the affidavit of Justice Nyangaya were of no probative value. The registrar's report shows that the original Forms 34A from the contested polling stations, which were allegedly intercepted, were exactly the same as those on the public portal, and the certified copies that were presented to this court pursuant to the provisions of Section 12 of this Supreme Court Act 2011. 4, regarding the allegation that the integrity of the public portal was compromised, this was disproved by evidence of consistent attributes such as unique timestamps, uniform PDF conversions at the polling stations, correct polling station mapping, and consistent KIMS reporting from verification to transmission of results. 6, the RTS was configured on a virtual platform network, VPN, and the SIM cards locked to a specific polling station. The server was also configured to accept results only from authorized and properly mapped KIMS kits. In our view, the petitioners failed to produce credible evidence to the contrary. 7, a review of some of the logs presented as evidence of staging showed that they were either from logs arising from the 2017 presidential election or were outright forgeries. In our considered view, there was no evidence of a man-in-the-middle server configured to the IEBC's VPN network, and no evidence was produced to show that the chairperson of IEBC and staff were part of the arranged conspiracy to stage the transmission process. 9, whether there was a difference between Forms 34A uploaded on the IEBC public portal and the Forms 34A received at the National Tallying Center, and Forms 34A issued to the agents at the polling stations. On this issue, the first petitioner's case was that there was deliberate manipulation and tampering with Forms 34A, as demonstrated in the affidavits, to the effect that votes were being deducted from the first petitioner and being added to the first respondent. To support this petition, evidence was contained in the affidavits of Honorable Martha Karua, sworn on 21st August 2022, Celestine Anyango Opio, Arnold Ochieng Oginga, and John Mark Githongo, which was sworn also on 21st August 2022, and a further affidavit sworn on 28th August 2022. Dr. Nyangasi also swore an affidavit on 21st August 2022, and so was Martin Papa, to support that allegation of handing and subtraction of votes. On the other hand, IEBC and its chairperson urged that all Forms 34A transmitted to IEBC portal were not interfered with or manipulated. Further, that the Forms 34A signed at the polling station and issued to the agents were identical to the Forms 34A uploaded on the public portal and delivered to the National Tallying Center at the Bomas. It was contended that in any event, IEBC used the original physical Forms 34A to tally, verify, and declare the presidential election results. This court ordered scrutiny of the forms from the 41 polling stations outlined in the affidavit of Celestine Opio, National Tallying Center at the Bomas. It was contended that in any event, IEBC used the original physical Forms 34A to tally, verify, and declare the presidential election results. This court ordered scrutiny of the forms from the 41 polling stations outlined in the affidavit of Celestine Opio to ascertain the allegation of interference. And this is our finding. 1, there were no significant differences captured between the Forms 34A uploaded on the public portal and the physical Forms 34A delivered to Bomas that would have affected the overall outcome of the presidential election. B, no credible evidence was presented to support the allegation that Forms 34A presented to agents differed from those uploaded to the public portal. The report by the registrar of this court confirmed the authenticity of the original forms in the sampled polling stations. The affidavits of Celestine Opio and Arnold Ochieng Oginga, while containing sensational information, were not credible, as the registrar's report confirmed that all the Forms 34A attached to those affidavits and purportedly given to them by the agents at select polling stations were significantly different from the originals, certified copies, and those on the public portal. The purported evidence of Celestine Opio and Arnold Oginga, sworn in their respective affidavits, are not only inadmissible, but are also unacceptable. It has been established that none of the agents on whose behalf the forms were being presented swore any affidavit, that there is nothing to show that they had instructed both Celestine and Arnold to act for them, yet the two have gone ahead to depone on matters that are not within their knowledge. This court cannot countenance this type of conduct on the part of counsel who are officers of the court. Though it is elementary learning, it has repeating that affidavits filed in court must deal only with facts which an opponent can prove of his own knowledge, and as a general rule, counsel are not permitted to swear affidavits on behalf of their clients in contentious matters like the one before us, because they run the risk of unknowingly swearing to falsehood and may also be liable to cross-examination to prove the matters deponed. We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 113 and 114 of the Penal Code that swearing to falsehoods is a criminal offense, and 2, that it is an offense to present misleading or fabricated evidence in any judicial proceeding. Section 114 of the Penal Code states, and I quote, "Any person who swears falsely or makes a false affirmation or declaration before any person authorized to administer an oath or a declaration upon a matter of public concern, and at such circumstances that the false swearing or declaration, if committed in a judicial proceeding, would have amounted to perjury, is guilty of a misdemeanor." One of the most serious losses an advocate may ever suffer is the loss of trust by judges for a long time. Such conduct amounts to interference with the proper administration of justice. The contents of the affidavit of John Mark Githongo, which may contain forgeries, are also dismissed for not meeting the evidential threshold. Those averments contain no more than incredible and hearsay evidence. No admissible evidence was presented to prove the allegation that Forms 34A were fraudulently altered by a group situated in Karen under the direction of persons named in the affidavit and video clip attached to it. As a matter of fact, these two affidavits amount to double hearsay and incapable of being proved at each of the rears. We turn to Form 34A for Gacharaigo Primary School, which was sensationally presented by Madam Judy Soweto, advocate, to show that one Jose Camango accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air, and we were taken on a wild goose chase that yielded nothing of probative value. The Kim's kit relating to Songonyo Primary School, which bore the same serial number with another, was admitted by IMBC as an inadvertent manufacturer's error. We are also satisfied that the two kits and other identifying features that were markedly different, including the timestamps and polling code, and therefore nothing turns on this anomaly. Therefore, to the question whether there was a difference between Forms 34A uploaded on the IBC public portal and those received at the National Tallying Center and those issued to the candidates' agents at the polling station, we have found none. Issue number 4, on whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui, Rural, Kachiriba, Rongai, and Pokot South constituencies, and electoral ones in Nyaki West, in North Imenti constituency, and Koanjenga in Embakasi South constituency, resulted in voter suppression to the detriment of the petitioners, and especially in petition number 5 of 2022. It is common knowledge that IMBC postponed elections for various seats during the general elections of 9th August 2022 due to mix-up of ballot papers in the above-named electoral units. It is the combined case of the first and second petitioners that in terms of Articles 136, 2A, 177(1), and 181 as read with Article 1(1) of the Constitution, the chairperson of IMBC had no jurisdiction to postpone elections in those areas. That Section 55B of the Elections Act is inconsistent with the Constitution and therefore void to the extent that it purports to donate to IEBC power to postpone elections in the constituency, county, or ward, contrary to the Constitution, and the postponement undermined the conduct of free, fair, credible elections by depriving the voters an opportunity to vote for all the candidates on the dates stipulated by the Constitution. The petitioners further contend that the postponement of elections and the overall effect of suppressing voter turnout in the electoral units in question, which was prejudicial to him. Both the first and third petitioners also believe that elections were deliberately postponed in Kakamega and Mombasa counties. It was arranged that these areas are considered to be first petitioner strongholds, and as such, the postponement of elections worked to his disadvantage and added that benefit to the second respondent. These assertions were denied by IEBC and its chairperson. They, however, admitted that they experienced confusion with the printed ballot papers and explained that they only discovered the mix-up on the eve of the election when the ballot papers were being distributed to the polling stations. That as a practice, ballot papers can only be opened on the eve of the election day to avoid any mischief, and that by the time the mix-up was discovered, it was logistically impossible to print and replace the ballot papers in time for the elections. For this claim to succeed, it must be demonstrated first, IEBC and no authority in law to postpone the elections in cases of emergency. We are therefore satisfied that on the basis of the foregoing provision, the third respondent and the requisite power to postpone election in the constituencies, counties, and wards in question. Concerning the allegation of voter suppression, we note that voter suppression is generally recognized as a political strategy which takes many forms, but whose practical effect is ultimately to reduce voting by deliberately discouraging or preventing targeted groups of people from exercising their right to vote and thereby to influence the outcome of an election. It therefore goes against the letter and the spirit of Article 38, which guarantees every citizen the right to make political choices based on universal suffrage. As regards this allegation, it has not been shown that by postponing elections in the named electoral units, IEBC acted in bad faith or was influenced by irrelevant factors and considerations. From the explanation tendered, we are satisfied that the postponement was occasioned by a genuine mistake, which in our view could have been avoided had the members and staff of IEBC been more diligent when they went to inspect the templates in Athens, Greece, where the printing of ballot papers was undertaken. In the absence of any empirical data, we cannot find a basis upon which to conclude, as a matter of fact or evidence, that the postponement affected voter turnout, as a consequence of which the first petitioner alone, as a presidential candidate, suffered disadvantage. At any rate, the nature of the ballot being an individual decision and secret, there may be other factors to which the turnout in the named units can be attributed. From the evidence on record, however, it appears to us that 2022 general election recorded one of the lowest turnouts. The postponement affected voter turnout, as a consequence of which the first petitioner alone as a presidential candidate suffered disadvantage. At any rate, the nature of the ballot being an individual decision and secret, there may be other factors to which the turnout in the named units can be attributed. From the evidence on record, however, it appears to us that 2022 general election recorded one of the lowest turnouts since the introduction of multi-party political system some 30 years ago. If there was a low voter turnout, it affected all the 6 categories of candidates, and its explanation, in our view, lies elsewhere, but certainly not a calculated suppression. On the other hand, in rebuttal to these claims, IEBC illustrated with examples to our satisfaction that there was no nexus between the postponement of elections and voter turnout in the affected units, far from the fact that this claim was undoubtedly just another red herring. It has nothing to do with the question under review, and accordingly we reject it and own that there is no proof that the postponement resulted in voter suppression to the detriment of the first petitioner. Whether there were unexplainable discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 5. The first petitioner was categorical that there was systemic ballot stuffing in certain counties, mainly in the Rift Valley and central parts of Kenya, where, according to him, a total of 33,208 votes were cast for president only, without corresponding votes for the other elective positions. On the part of IEBC and the chairperson, while acknowledging that indeed in some instances there was vote differential between those cast for president and for other positions, but maintained that they were insignificant, and those instances related to votes by prisoners and citizens in the diaspora who only vote for the president but did not take part in other elective positions. The differential also includes rejected ballot papers and stray votes which do not count as valid votes. It's a particular direction. Not a single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypothesis that since the number of votes cast for the president is higher than those for other positions, then, without more, it must follow that there was fraud. We find that fraud is a serious criminal offense, and it must be proved beyond reasonable doubt under Section 5N of the Election Offences Act. It is indeed an offense for a person to vote more than once in any election. IEBC has profound a plausible explanation for the vote differential, citing categories of voters who only vote for the president, such as prisoners and Kenyans in the diaspora. There were an insignificant number of stray votes whose combined effect cannot justify nullification of the election. Finally, on this point, a general election in Kenya comprises of 6 different separate elections held concurrently on the same day. Such elections are held by secret ballots, and one cannot predetermine the voter turnout or how voters will vote in each election. None of the parties has flagged anything so significant that it would have affected the outcome of the presidential election vis-a-vis the other 5 elections held on the same day. We find, therefore, there were no unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. On issue number 6, whether IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138, 3C, and 138(10) of the Constitution. This issue arises from the printings in all the petitions as consolidated. Based on the sealed printings, the affidavits sworn in support thereof, and the written and oral submissions by parties, two viewpoints regarding the meaning, scope, and application of Article 138, 3C, and 10 of the Constitution have been advanced. On the one hand, the petitioners submit that pursuant to the foregoing provisions, the role of verifying and tallying of votes as received from polling stations countrywide is vested in the Commission as a corporate entity and not the chairperson of the Commission. It is their argument that the chairperson cannot undertake this task to the exclusion of other commissioners. They submit that the language of Article 138(3)(c) does not envisage a situation where the chairperson can arrogate to himself unfettered authority to verify and tally the results at the National Tallying Center without involving the other commissioners. Such action, they contend, would not only be unconstitutional, but would be sufficient ground without more to nullify an election of a president-elect. In support of their argument, the petitioners cite the Court of Appeal decision in IEBC versus Mainakiai and 5 others as affirmed by this court in the case of Raila 2017. The petitioners further submit that Regulation 87(3) of the Election General Regulations is unconstitutional to the extent that it purports to vest the power of verification and tallying in the chairperson of IEBC. On the other hand, the first, second, and third respondents submit that power to verify, tally, and declare results of a presidential election at the National Tallying Center is the exclusive preserve of the chairperson of IEBC. According to them, there is nothing unconstitutional about Regulation 87(3) of the Elections General Regulations. The said regulation the respondents submit makes no mention of commissioners other than the chairperson. At any rate, the respondents argue Article 138(3)(c) of the Constitution does not envisage a situation where it is the commissioners who personally undertake the task of verifying and tallying the results as entered into the thousands of Forms 34A. Such an undertaking would be humanly impossible, they submit. For good measure, the respondents submit that Section 11A of the IEBC Act provides that the chairperson and members of the Commission are responsible for the formulation of policy and strategy of the Commission and oversight. In their view, the Act does not contemplate a situation where commissioners would be directly involved in the verification and tabulation of presidential election results. The task of verification and tallying, as stated by the respondents, is executed by the staff of the Commission under the direction and supervision of the Commission Secretary, who in turn reports to the chairperson. As to whether the chairperson acted unilaterally in verifying and tallying the presidential election results at the National Tallying Center, The petitioners claim that indeed this is what happened. It is the petitioner's case that the chairperson published an illegal Gazette notice number 4956 of 2022, in which he designated himself as the presidential returning officer, a position unknown in law and the Constitution. Having done so, the petitioner states that the chairperson proceeded to conduct the verification and tallying process to the exclusion of other commissioners, each of whom he had assigned territorial roles and related to the verification and tallying exercise. On his part, the chairperson of IEBC submitted that although he has the exclusive authority to verify and tally the presidential election results as received at the National Tallying Center, he did involve the other commissioners in the exercise before eventually declaring the final results. He submitted that he did this in the spirit of teamwork. The chairperson of IEBC states that indeed the 4 commissioners were involved in the preparation of the 9th August general elections from the time of their swearing into office all the way to the verification and tallying of results at the National Tallying Center until they withdrew from the exercise just when he was set to declare the final result. Having considered all the parties' submissions, we find that pursuant to Article 138(3)(c) of the Constitution, the power to verify and tally presidential election results as received at the National Tallying Center vests not in the chairperson of IEBC, but in the commission itself. The latter carries out this exercise through its secretariat staff, technical personnel, and any other persons hired for that purpose under the oversight and supervision of the chairperson and the other members of the commission. In line with this court's decision in Raila Odinga versus another versus IEBC and 2 others, as reported in 2017 Kenya Law Report, popularly known as Raila 2017, and the Court of Appeal decision in IEBC versus Maina Kiai, we also find that the chairperson cannot arrogate to himself the power to verify and tally the results of a presidential election to the exclusion of other members of the commission. Indeed, Article 138(10) of the Constitution, although the power to declare the result of a presidential election after verification and tallying is vested in the chairperson, he does so only as a delegate of the commission. Consequently, to the extent that Regulation 87(3) of the Elections General Regulation purports to vest the power of verifying and tallying presidential election results as received at the National Tallying Center solely on the chairperson to the exclusion of other members of the commission, the same is contrary to and inconsistent with the provisions of the Constitution. That said, we, however, take cognizance of the fact that the 4th, 5th, 6th, and 7th respondents, referred to as the 4 commissioners, actively participated in the verification and tallying exercise from the beginning up to the and until just before the declaration of the results by the chairperson. They took turns announcing the results as verified and tallied, and were present and active during the actual verification and tallying at Bomas. An example is when one of them, Justice Nyangaya, stood on the podium to announce to the public results and also announced an adjustment that had been occasioned by errors of tabulation. The events of 15th August 2022, therefore, came as a surprise. As the public waited for the chairperson of IEBC to declare the final results, Sporadic violence broke out at Bomas. The violence swiftly was contained by the security forces, but there was unexpected drama as two different factions of the commission began to emerge. Kenyans found themselves watching an appalling split-screen scenario on their television sets. On one part of the screen was the chairperson readying himself to declare the results in accordance with Article 138(10) of the Constitution. On the other part of the screen were the four commissioners on the runs of the Serena Hotel, Nairobi, from where they announced that they would not own the results that were soon to be declared by their chairperson. The four commissioners informed the public of their rejection of the yet-to-be-announced results, terming them opaque due to the manner in which the chairperson had been conducting the verification and tallying exercise. In his affidavit dated 25th August 2022, Justice Nyangaya averred that the chairperson's actions during the tallying and verification exercise at Bomas made it difficult to ascertain the total number of votes cast and the actual number of votes attained by each candidate, so as to enable him authoritatively state the commission and declared accurate results. All the petitioners have anchored their arguments for the nullification of the 9th August presidential election in Taharia on the walkout from the Bomas by the four commissioners. They contend that by rejecting IEBC's results on grounds of opaqueness of the verification and tallying process, they called into question the credibility of the entire election. They further submitted that being in the majority out of the 7-member commission, their view should prevail and the election should be nullified. It is the petitioner's argument, therefore, that a dysfunctional commission cannot deliver a credible election. We note that apart from their 11th hour denunciation of the verification and tallying process and their averments regarding the conduct of the chairperson, the four commissioners have not placed before this court any information or documents showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson. Critically, they have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, at the Serena Hotel press briefing, the four commissioners acknowledged that thus far the entire election had been managed efficiently and credibly. The chairperson on his part did not make matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks of midwifing our democracy, an institution that obviously needs far-reaching reforms, of which we shall say more in our detailed reasons. But are we to nullify an election on the basis of a last-minute boardroom rapture, the details of which remain scanty and contradictory between the chairperson of the commission and some of its members? In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people are participating without hindrance, as they made their political choices pursuant to Article 38 of the Constitution? To do this would be tantamount to subjecting the sovereign will of the Kenyan people to the quorum antics of IEBC. This we cannot do. Clearly, the current dysfunctionality at the Commission impugns the state of its corporate governance, but does not affect the conduct of the 2022 election. In view of the foregoing, we are satisfied that notwithstanding the divisions apparent between the chairperson and the 4 commissioners, IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 10 of the Constitution. Issue number 7, whether the declared President-elect attained 50+1 of all the votes cast in accordance with Article 138 of the Constitution. The first, second, and third petitioners averred that the first respondent did not garner 50%+1 of the total votes cast, and therefore did not meet the threshold provided by Article 138(4)(a) of the Constitution. They anchored their claims on the basis that in order to determine whether a candidate has attained 50%+1 of the votes cast, this ought to be calculated based on the total number of votes cast, excluding rejected votes. They argued that 50% of 14,353,165 votes, in their view, were the variant votes cast, which amounted to 7,176,582.77 votes. They therefore contended that by attaining 7.176141 votes, the first respondent did not meet the constitutional threshold to be declared President-elect. Supporting the claim that the first respondent did not meet the 50+1 constitutional threshold was the 6th petitioner. His contention was founded on the backdrop of a press briefing issued by the chairperson of IEBC after the official closure of voting on 9th August 2022. According to the 6th petitioner, the chairperson of IEBC announced that the voter turnout was 65.4% of the total number of registered votes based on the verification of the KIMS kits which were functional during the process of voting. In addition, the 6th petitioner urged that the voter turnout of 65.4% did not include some 238 polling stations where the KIMS kit had malfunctioned, necessitating use of the manual register. It was therefore urged that the minimum number of votes cast could not be less than 14,466,779. Additionally, that this number was bound to increase once the number of votes from the areas that used the manual register were included. The 6th petitioner further claimed that a summation of the minimum number of votes cast and untallied manual votes would represent the actual voter turnout. In challenging the declaration made by the chairperson of IEBC, the 6th petitioner averred that the final tally published in Form 34C only accounted for 14,326,641 votes cast, including some 113,614 rejected ballots. The 6th petitioner contended that this tally did not factor in some 140,138 votes cast using the manual register. The 6th petitioner computed this number by subtracting 14,326,641 declared votes cast from 14,466,582 779 generated by the sixth petitioner as representing 65.4% of the voter turnout. Referring to the tariffs in Form 34C, the sixth petitioner summed the number of votes cast for each candidate as follows. Raila Odinga, 6,942,193. William Ruto, 7,176,141. Wahiga Mwaura, 31,987. And George Wajakoya, 61,969, adding to a total of 14,213,027. He then added 140,138,000 arranged to be untitled votes, and this yielded a total of 14,353,165 total valid votes, which the sixth petitioner used to compute the percentages garnered by each candidate as follows. William Ruto, according to him, garnered 49.9%, Raila Odinga 48.3%, Wahiga 0.22%, and Wanjakoya 0.3%. It is on this basis that the sixth petitioner grounded the claim that none of the candidates met the constitutional threshold as set out in Article 138(4)(a). IEBC and its chairperson disputed the sixth petitioner's claim. They submitted that the declaration of results is based on the number of people identified as having voted on the KIMS kit and not the total persons on the voters register as arranged. They contended that the final voter turnout comprising of the voters who were identified through the KIMS kit and those who voted manually was 64.76% and not 65.4% as arranged by the petitioners. They urged that the announcement error by the chairperson of IEBC on 10 August 2022 was immediately clarified during the same press briefing. And evidence of this correction was provided to this court in an affidavit of the first and second respondents in Presidential Election Petition number 7 of 2022. According to IEBC and the chairperson, 14,239,862 voters were identified using the KIMS kit, while 86,889 voters were identified using the printed voter register. Therefore, the total valid votes cast were 14,213,137, while the total number of rejected ballots were 113,614, constituting 14,326,751 total votes cast. They illustrated that the first respondent garnered 7.176,141 votes against 14,213,137 total valid votes cast, yielding a percentage of 50.49 to meet the requisite constitutional threshold for a candidate to be declared president-elect. In the upshot, the percentage attained by each candidate was as follows. Raila Odinga 48.84%, William Ruto 50.48%, Wahiga Mwaura 0.22%, and George Wanjakoya 0.43%. IEBC and its chairperson also submitted that the KIMS kits malfunctioned in 235 polling stations, necessitating the use of the printed voter register. In these polling stations, backup KIMS kits were later deployed for purposes of results transmission. The first respondent, in response to the question of 50+1 constitutional threshold, maintained that he attained the threshold under Article 138(4) of the Constitution as elaborated by the IEBC and the chairperson. This court has considered the differing formulas and threshold arguments presented by various parties to this petition, while the first, second, and third petitioners raised pertinent questions connected to this issue. We shall address them together with those of the sixth petitioner, who has addressed and focused on the issue as specifically framed in detail. It must be restated that the case made by the sixth petitioners concerns a data-specific threshold as enunciated under Article 138(4) of the Constitution, that without attainment of which there can be no declaration. This data-specific threshold is what this court declared in John Arun Mwau and two others versus IEBC and others. Petitions numbers 2 and 4 of 2017, consolidated, referred to as the ultimate yardstick for determining the winner in a presidential context. In Raila Odinga and 5 others versus IEBC, petition number 5, 3, and 4 of 2013, this court asserted that rejected ballot papers do not constitute a vote cast to be included in calculating the final tally in favor of a presidential candidate. We are not persuaded by amicus curiae's brief, that is Law Society, who attempted to persuade us to consider our position on this finding. We reiterate that rejected votes cannot be taken into account when calculating whether a presidential candidate attained 50% plus 1 of the votes cast in accordance with Article 138(4) of the Constitution. Similarly, in the same Raila 2013 case, the court further laid down the parameters of burden and standard of proof in electoral disputes. More specifically, the burden and standard of proof required in disputes challenging the outcome of a presidential election. And this is what the court said, I quote, in the case of data-specific electoral requirements, such as those specified in Article 138(4) of the Constitution, for an outright win in the presidential election, the party bearing the legal burden of proof must discharge it beyond any reasonable doubt. The question that follows was whether the petitioners challenging the attainment of 50% plus 1 constitutional threshold and the computation by the sixth petitioner in general met the standard of proof settled by this court in Raila 2013 case. The premise of the sixth petitioner's percentage computation was a press briefing made by the chairperson of IEBC on 10th August 2022, when the evidential burden shifted to IEBC and its chairperson, as it does in election cases. They produced video evidence correcting the percentage voter turnout to read 64.6 at the time of the briefing. This percentage, however, did not include reports from all the Kim's kits and 86,889 voters who were identified manually using the printed register of voters. In our view, the assertion by the sixth petitioner that the percentage voter turnout was firstly predicated on the uncorrected percentage given by the chairperson of IEBC was negated by evidence adduced to prove the correction. Secondly, the sixth petitioner based his percentage of voter turnout on the total number of registered voters, while the chairperson of IEBC made reference in the press briefing to the number of registered voters who were identified through the Kim's kits progressively. The sixth petitioner also asserted that rounding off of votes cast in a presidential election as a means of assessing the threshold under Article 138(4) of the Constitution kills and bars voters, which is illegal and unconstitutional. We have deliberated on this proposition and found that it is not mathematically sound and that the rounding off done by IEBC and the chairperson was correct. Consequently, we find that the petitioners did not provide a watertight case to warrant the setting aside of the results of the presidential election on the basis of not having met the threshold provided under Article 138(4)(a) of the Constitution. On the voter turnout, therefore, we find that the formula predicated on the number of voters identified through Kim's kit progressively and used by IEBC and the chairperson to generate a percentage of 64.76% was correct. Having settled the issue of voter turnout, we must ask ourselves whether in the making of the declaration, the chairperson of IEBC applied the formula in Article 138(4) of the Constitution, which is total votes cast less rejected votes divided by 2 must always give 50% plus 1 vote. Given the numbers that were presented to us by IEBC and the chairperson, this would translate to 14,213,137 divided by 2 plus 1, which makes 7.106569. The question that must inevitably follow is whether this formula, when applied, will confirm that 7,106,569 votes is less than 7.176,141, which represents the number of votes received by the first respondent. We find that it is, as such, on the basis of the foregoing formula and from the numbers provided by IEBC and the chairperson and the declaration by the chairperson of the president-elect on 15th August 2022, it is our finding that the declared president-elect attained 50% plus 1 of all the votes cast in accordance with Article 138(4) of the Constitution. Issue number 8, on whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. Although the petitioners have provided numerous averments pointing to possible irregularities and illegalities marked by failure of technology, arranged voter suppression, printing and utilization of Book 2 of 2, EO preparation by the IEBC and its chairperson, commission indiscretions, transposition anomalies, agent absence, and many others, we are of the view that the pointed illegalities and irregularities were not of such magnitude as to affect the final result of the presidential election. We will delve deeper into the details of this issue in our recent judgments. Last issue, what reliefs and orders can the court grant? Under Article 163(3) of the Constitution, it is provided that the Supreme Court will have A, exclusive original jurisdiction to hear and determine disputes relating to the election of the office of the President arising under Article 140. And Article 140 provides, I quote, a person may file a petition in the Supreme Court to challenge the election of the President-elect within 7 days after the date of the declaration of the results of the presidential election. 2, within 14 days after the filing of a petition under Clause 1 the Supreme Court shall hear and determine the petition, and its decision shall be final. If the Supreme Court determines the election of the President-elect to be invalid, a fresh election shall be held within 60 days after the determination. In exercising its jurisdiction pursuant to these provisions, the court sits as an election court with a mandate to determine the validity or otherwise of the election of the President-elect. It is clear to us that the jurisdiction of the court is quite circumscribed in terms of the orders or reliefs it can grant following the hearing and determination of the election petition under Article 140 of the Constitution. In the event the court determines that the election of the President-elect is invalid, it must make an order nullifying the election. Consequently, it has also to make an order directing IEBC to hold a fresh election within 60 days after the determination. Should the court determine that the election of the President-elect is valid, it shall issue a declaration to that effect. The court has then, as a matter of course, to make an order dismissing the petition with or without cost, as the case may be. In the strict sense, therefore, these are the only orders that the court may make under the Constitution. The court cannot assume jurisdiction that goes beyond the purview of Articles 163(3) and 140 of the Constitution. However, nothing stops the court from issuing orders or reliefs by way of recommendations. Indeed, since 2013, this court has issued many recommendations arising from the determination of 3 petitions challenging the election of the President-elect. The recommendations are meant to improve our electoral landscape and hence aid in the development of our democracy. In this regard, this court has been greatly aided by the contributions also of the amici curie, and the court places a heavy premium on those briefs that were filed and those which were admitted. The final orders made by the courts. This is a unanimous decision of the court, and we make the following orders. 1, the presidential election petition number E005 of 2022 as consolidated with the presidential election petition numbers E001, 2, 3, 4, 7, and 8 of 2022 are hereby dismissed. As a consequence, we declare the election of the first respondent as President-elect to be valid under Article 143 of the Constitution. This being a matter cutting across the public interest, we order that each party do bear their own costs. It is so ordered. And finally, the court has asked me to also acknowledge, although we'll do it in the long draft, the enormous contribution made by counsel in these proceedings, and also the orderly way the counsel, all the advocates and parties conducted themselves. They remained seated throughout the proceedings. That is the judgment of the court, a unanimous one. We shall issue a media summary to help the media summarize the case. I think that is all. Thank you very much for coming.
My Lady, Madam Chief Justice, and the learned judges of this court, again, I am requested by my colleagues to thank you most profusely for your labors into delivering this judgment, listening to all of us, and giving our nation this judgment so that we may move forward. Thank you, and God bless you.
It may please the court. It is not true that I asked the Attorney General Emeritus to talk on our behalf. Next time you should talk to me. Let me similarly, on behalf of the lawyers for the counsel for the first and second petitioner, thank the court, and it has been a journey, worthwhile journey, sitting through these proceedings, and we thank the court for your patience and for the delivery of this judgment within the time stipulated. We thank you.
Madam President, members of the court, I wish to request just a couple of minutes for the chairperson of the Law Society of Kenya to make a few remarks in appreciation of the work that the court and Kenyans have done on this exercise, if you allow. Thank you. I call upon Mr. Eric Theuri to come and make his remarks. It is also his birthday. I would have sung happy birthday for him.
My Lord, the Chief Justice of the Republic of Kenya, the President of the Supreme Court, the Deputy Chief Justice and all the Justices of the Supreme Court, I think it would only be fair that I make my remarks after counsel for the respondents, Senior Fred Ngatia, makes his remarks to the court.
Madam Chief Justice, thank you very much. It's so kind for the President to acknowledge that age goes before youth. Mine is to thank the court, to thank my learned friends for the effort we all expended. We thank this court for clarifying certain issues, and we look forward to a less corrosive 2027. Thank you very much.
Madam Chief Justice, Madam Deputy Chief Justice, it's so nice to have two madams at the same time, and members of the court. Since there are only men talking, I decided that I should become a woman and talk. It's become too much of a male affair in here. But on behalf of well, I think we were the third petitioner, I wish to thank you, and you've clarified the Regulation 87.4, which I was feeling very passionately about, that it was unconstitutional from what I've heard. But thank you very much for the time you spent, and we do apologize if at times we looked like hooligans. I mean, you have said we behaved well, but we didn't behave as well as we should have. But thank you very much for your time and for delivering this judgment.
Madam Chief Justice, Madam Deputy Chief Justice, members of the court, I, on behalf of Attorney General, take this opportunity to thank you most sincerely for a great job done and for the courage to clearly define the limits of the law, which will help us empower IBC on the way forward, and hope that this might be the last of the petitions after elections once we carry out a proper elections based on your guidelines. Thank you.
The Chief Justice and the Justices of the Supreme Court, on a light note, my members would be extremely worried if we take the submissions of Senior Counsel Orengo that this should be the end on account of fees.
But my lady, Chief Justice, on behalf of the Law Society and all the members of the society, we wish to, first of all, take this opportunity to thank the court in the manner in which it has conducted these proceedings, extremely efficient, especially in light of the really short and strict timelines that you've had. But the management of the proceedings, the manner in which the court adopted a somewhat inquisitorial nature to the conduct of these proceedings is something that as a society we have noted, and we wish to commend the court. And we do hope that the other courts, as they determine any petitions, election petitions that will go before them, will similarly adopt such inquisitorial attitude, so that we try and really enrich the process that these proceedings intend to achieve. Secondly, I wish to also thank the council, all the advocates who have appeared before you. They have demonstrated extremely high standards of decorum and courtesy, and have also demonstrated a flair for persuasion of the court, including the use of PowerPoints, and of course the now famous Pinky Pinky Ponky mimic. But all that really, I'm sure, has demonstrated, especially to the younger members of the society, how to conduct themselves before the court and how to really prepare a persuasive brief. And we thank all the advocates who appeared before this court for the good work that they have done. And of course, as a society, we feel extremely proud that they have been able to raise the profile of the advocates in this country a notch higher from their presentation. So, my lady and my lord, it's not lost to us that at the end of these proceedings, and once we are able to get your judgment after 21 days, that it is democracy and the Kenyan people who are the winners. The decision today, in a way, validates the choices that were made by the Kenyan people on the 8th of August, and they also help to build confidence in the institutions that manage the elections and the court. We recognize that no country is born as a democracy, and that it is a process, and the process of challenging an election, as has happened before this court, is part of the processes of building confidence within the electoral system. And we thank all the petitioners for choosing to challenge the results before this court. But at the end of the day, Kenya stands tall as a beacon of democracy, and we are very grateful that we've had this opportunity also as a law society to appear before the court and to give an amicus brief which the court has had time to consider. So we thank you and we wish you a good day. I know it has been a long 14 days, but you can rest, and we'll be looking forward to the decision that you deliver within 21 days. Thank you so much, my lady and justices of the Supreme Court.
Thank you, Mr. President. I have been asked by the President of our court to react to your submissions, and in so doing, I am obliged to say that we are truly humbled by the statements that you have just made. More humbled because those statements come from both sides of the divide. And thank you for appreciating what we have to do within a very short while. Thank you for appreciating that it wasn't our wish that we were doing what we were doing. We were doing the wish of the Constitution of Kenya 2010, the laws of the Republic, the facts of the cases that you placed before us, and the evidence in rebuttal. We know that, and we have repeatedly said this, the President and I, whenever we have had time to talk to you in other fora, that we are incomplete without this side of the bar. We are incomplete without the advocates. We thank you. We will get opportunity to do that in the main judgment, in the reasoned judgment. But we really appreciate your industry. We were impressed by the submissions you took. And we were impressed, and we said this the last 3 days, I'll tell you something about that in a minute, by how deeply you believed in your clients' cases. That we think is a mark of an extremely grown legal profession, and we ask that you do not bring the bar down. You keep taking it up. In any contest of whatever nature, and even if we say there are no winners and losers, and even if we say that the winners are the Constitution and the people of Kenya, the truth is that some 6 million Kenyans will not be happy today. But that's the nature of the work we do. What we hope, and we hope you can advise your clients and our brothers and sisters that are the Kenyan people, that is what was expected. One side had to win. One side had to be in total or a great extent of compliance with the Constitution and electoral law than the other side. That's how we saw it. We thank you very much. We, the 7 of us, have not slept since we parted company on Friday. I think it is showing on our faces. And we thank you that you appreciate that we work under difficult circumstances, especially because of time. As ground rules, we agreed when we left you here on Friday that we would not pick any of your calls. A lot of you called us, but we just couldn't pick your calls. And I hope you understand that we couldn't. We saw that you were trying to call us, but we just could not pick the calls. I hope you understand. And now if you allow us, again, on behalf of these 7 men and women, thank you very much for appreciating what we have to do. Thank you for giving us the honor to serve this country in these capacities. And let's hope that we can continue to grow our democracy this way. And thank you very much for everything you also do for the country. And now you allow us to go home and sleep.
Thank you. The court is adjourned.
My brother Kirago, I have a message for you.
Well done. President, you make us make us proud. This guy brings us as one, and that is what we've always wanted. Yeah. And when you are near this man, tons of wisdom.
All right, now Choice 2022, the coverage of this election, the Supreme Court hearing. I guess now we've almost come to the end of this until we get to what we call the swearing-in ceremony. Those are live pictures from the Supreme Court, where a 7-judge bench was delivering their verdict, and in that verdict, they upheld the victory of President-elect William Ruto, dismissing the petition that was filed by the Right Honorable Raila Odinga and Martha Karua. And just to get some insights on exactly what was happening at the Supreme Court, my guest is still here in studio with me, just for a few minutes, making sense of that particular verdict. Celebrations have already started across the country, with the Kenya Kwanza team appreciating what has happened. And also, let me just take on the other side of the political divide. Martha Karua says the court has spoken. I respect but disagree with the findings. Earlier on, they had indicated that whatever ruling the court is going to give, they are going to abide by that and respect that whichever way it goes. She says the court has spoken. I respect but disagree with the findings. Now, the Supreme Court judgment was actually anonymous. It was read by the President of the Supreme Court, that is Chief Justice Martha Koome, and it was an anonymous decision to dismiss the 2022 presidential election petition and uphold the election of President-elect William Ruto, or rather his victory. There are quite a number of things that they were touching. Remember, there were 9 issues that they were looking at, and she went through each one of them, the 9 of them, trying to give the reasons as to why they don't agree. Most of them saying it was because of lack of sufficient evidence and not being persuaded enough to actually make a ruling in favor of the petitioners. And that is why this afternoon we have President-elect William Ruto. All right, let me come to you. What do you make of the ruling today, that has just happened right now? Yes, I know we'd spoken about it earlier on, and you said the evidence that had been presented in court was not sufficient, and you didn't believe actually that there are going to be a nullification or anything like that.
We welcome the decision of the court. Mm-hmm. I do thank my senior Martha Karua, though she respects it, mm-hmm. but she's entitled to her own opinion. Okay. Life must move on. Okay. Elections are expensive in Kenya, mm-hmm. and you know the impact it causes. Mm-hmm. Congratulations to the President-elect, mm-hmm. and to the Deputy President-elect. The
Deputy President-elect, Rigathi Gachagua, and President-elect William Ruto. Those are going to be our leaders now from now on. Now, from here, where do we go in respect to this particular decision? What's next now? What's the process of now trying to ascend to power?
The next process, mm-hmm. as we know, is the gazettement, mm-hmm. of the swearing in, which it's supposed to be done according to our constitution. Mm-hmm. The next Tuesday, after 7 days of declaration, mm-hmm. that takes us to next week on 13th of September. Mm-hmm. Also, we have the assumption of the assumption office of the President Committee, mm-hmm. led by Mr. Kinyo. Mm-hmm. They're going to gazette the process that is going to be followed. Thereafter, we are going to see security briefings, okay. on the President-elect and the incumbent President, mm-hmm. on how power will be transitioned. Okay. Yes.
So on 13th of this month, then we will be preparing to swear in President-elect William Ruto as the 5th President of the Republic of Kenya, I believe so. And just to look at some of the reasons that were given in regards to the 4 commissioners have not placed before the court and documentations of evidence to show that the election was compromised. They have not explained why they participated in a verification process when they knew it was actually opaque. That is one of the reasons that has been given by Chief Justice Martha Koome in regards to that. And we talked about it earlier, just looking at the commissioners and who exactly has the power. What's your take on what she actually delivered today in regards to that particular issue out of the 9?
I really thank the CJ for bringing that issue very well, mm-hmm. and articulating on that issue very well. she said that you cannot bring boardroom discrepancies at the final end of a process. They should have raised it earlier on, even before the election, so that we could have known the way to solve that issue.
Okay.
But once you bring it afterwards, that one cannot be taken. Yes.
All right, so then where do we go from here when it comes to commissioners and the IBC chair? Because one of the things she said was the power to verify vests in the commission itself. The chairman cannot allocate himself powers to tally the results at the exclusion of other commissioners. However, the 4 commissioners actively participated in the verification and took turns to announce the results. This is according to the CJ when she was actually giving that particular verdict. So did them taking part in actually being seen on screen, giving results from different parts of the country, contribute to, you know, that process where we say it's a tallying process that incorporated all of them?
Yes, yes. They cooperated together in tallying. However, the CJ has brought the issue of the CJ, the chairman of IBC working alone. I think it is time that the chairman and the 3 commissioners and the 4 commissioners, let bygones be bygones and let them come together and work for the unity and the prosperity of our country, Kenya.
Okay. Talking about now, because a lot of issues have actually been dismissed, but this was a case that when the petitioners were heading to court, they were very confident that they had enough when it comes to evidence. Where did they go wrong when it comes to convincing the courts? Was the evidence as hot air as put it as it has been put by Chief Justice Martha Koome, or maybe they just lacked enough, you know, arguments to actually convince the courts?
The lorry that they took, it was full of hot air, just as the way CJ has said. The other thing, the CJ has raised issues on affidavits that were presented in court.
Okay.
We've seen an advocate who signed and witnessed affidavits on behalf of client. That is not allowed in law. I think it is now upon the relevant authorities to charge the said person according to the penal code. Also, the issue of affidavits by John Githongo. You do not produce hearsay affidavits before court. Hearsay evidence are not allowed before court. I think it is this judgment has made firm ground rules on our laws as it is. We should uphold the Evidence Act as it is. We should also uphold the rules, the Supreme Court rules on how do you present evidence before court. You saw there were issues on technology. You need to raise notice on how you need to produce that evidence, and it's upon now the registrar of the Supreme Court to see whether that evidence is admissible.
Okay.
Yes.
We also touched on something when we were having this conversation earlier on, just before we headed to the Supreme Court, on the issue of postponement of results, of elections rather, in 2 counties and other constituencies and wards across the country that could actually have led to voter suppressions. Again, you know, Chief Justice Martha Koome comes and says, okay, the low turnout was actually across the country, so we are not actually convinced when it comes to that.
Yes, yes. I do thank the CJ for sharing the same sentiments with her. Because I do not think that there was voter suppression. And it has been clearly been said and brought out by the Supreme Court. And I think it is now upon IBC and the politicians to encourage voters to turn out to vote. Yes.
Okay. So something else, Koome says, IBC illustrated with examples to our satisfaction that there was no nexus between the postponement of elections and voter turnout. That's exactly what we've been talking about. Let's come to another issue, whether there was messing with the, you know, the portal itself, the IBC servers, as it had been alleged earlier, that the petitioners say that somebody, Jose Camargo, was actually sitting there and waiting to change results and all that. But then again, the Supreme Court has actually dismissed that and says, well, whatever IBC has explained to us on how it happened, we are convinced that there was nothing like messing with the server. Then again, was it in, should I say, probably the IBC side arguments were stronger than the petitioner's side?
the respondents, IBC, they responded very well. They presented counter evidence to counter-attack on the evidence raised by the petitioners. We also saw that no evidence raised by IBC, especially by Advocate Mahat, none of them has been challenged. They've challenged the issue of my senior, Madam Soweto. They've challenged her evidence, and that clearly puts it out on how credible the evidence by IBC was. Yes.
So they had good evidence.
Yes, they had good evidence, which overturned the evidence raised by the petitioners.
Right. And something also just in relation to that, there was no significant differences between Forms 34As uploaded on the portal and those delivered to the other boroughs of Kenya, because this was also an issue, because looking at what had been tallied in the 41 constituencies that had actually, you know, the Supreme Court directed that we recount those results, I found that there was no much difference. Most of it was actually the same with what was at the portal. So in terms of differences, again, that actually got to be dismissed because they find that there's a lot of sync when it comes to the physical forms and actually those that were in the portal of the IBC. Most of these 9 issues actually, you know, come together just being dismissed one by one. At what point did we notice that this was actually going to, you know, go the Kenya courts away and uphold this election?
In law, we usually know by the first issue. When the first issue is usually determined in favor of one side, we know how the rest of the other issues will flow. Because if the Supreme Court could have found issues with technology, we voted via technology using the KIMS kit and everything. All the systems, identification was electronic. It was only voting that was done manually and counting. But the rest of the process from tallying to transmission to even declaration, it was done electronically. So that is how we predicted. And by the evidence that was tabulated before court, as I told you earlier on, I did not see the Azimio side having the petitioners having a watertight case before the court.
And that's exactly, it has been proven that there's probably no enough evidence, no good case to actually lead to a nullification of the presidential election. This is Choice 2022 coverage of the 2022 general elections. We do this until the day we have the president-elect sworn in office, and that will be on the 13th of September. This month, I mean, and where we are going to be swearing in the president-elect and the deputy president-elect so that they assume power and start their business. All right. Also, just Parliament right now and the Senate have there's a communication that they'll be having their first sitting, right?
Yes.
And so business is getting back to now. We start seeing government run.
Yes.
Thank you so much. That is our time, I guess, here. Mwendwa, thank you so much for your time and getting time to have this conversation here on Look Up TV, Choice 2022. All right, now, President-elect William Ruto's victory has been upheld by the Supreme Court. The 7-judge bench unanimously agreed to uphold the election and said that the evidence provided in court by the petitioners was not enough to lead to a nullification. All the details of that will be coming your way in 21 days. That is when they'll give the full reports, but in our subsequent bulletins also will be giving you the details of exactly what has happened, breaking it down in a way that you get to understand. My name is Brian Amuai. I leave you for now. See you later.
Badilisha maisha yako na kuachua chapa. Jishindie shilingi 1,150 pesa taslimu kila siku kupitia vipindi maarufu uvipendavyo katika runinga ya Look Up TV. Maelekezo ili ukaweze kuwa mshindi ni rahisi sana. Kwa simu yako ya mkononi, ingia kwenye M-Pesa. Elekea kwa Paybill, weka nambari 636395. Kwa account name andika neno Look, Kisha kwa amount weka shilingi 99 au 99 shillings. Kwa M-Pesa Paybill weka nambari 636395. Account name andika Luke. Amount weka shilingi 99 au 99 bob peke yake. Kumbuka, unavyocheza mara nyingi ndivyo